meeting today. So Tenant Protection Act in practice. And again, this isn't about property management. We don't do property management. This is about leasing and some things you should be looking for. This is also mainly when you are either listing or selling a tenant-occupied property and basically how to handle those situations. And why am I bringing it up? Well, we've had a couple flare-ups with selling properties with tenants in place. And we all know that can be a bit of a challenge, and we need to make sure that we are going through the proper steps when dealing with those properties, especially with the tenant, and not infringing on their quiet enjoyment of the property. Um, so this is why this meeting is actually fairly important because the tenant occupied properties do come up quite often. So let's go ahead and roll right into it. So the Tenant Protection Act. So this isn't new necessarily, but there are a lot of restrictions that came with this, and we deal with them on a daily. So this is why we're going to cover this today. So um, let's talk about the rent cap portion of it. So this is a part where if you're doing leasing, again, not property management, but leasing, you are putting a tenant in place for a rental property owner, then these are some things that you should know about that. So rent increases on covered unit are capped at 5% plus the local consumer price index or 10%, whichever is lower. So local matters. The CPI used depends on this property's metro area, and it changes every August. So pretty good timing right now. LA, Orange County, you're looking at 8.7 for the period August 2026 through 27. It was 8% the year before. Riverside, San Bernardino, 8.1 based on March CPI. San Diego, 8.2. San Francisco, Alameda, Contra Costa, Marin, just up north, you're looking at 8.8. So don't automatically assume 10 when you are doing leasing and you're talking to this rental property owner and they're saying how much kind of increase the rent. It's not necessarily going to be 10. You have to do a little math here and figure out based on the location of that property. A few mechanics worth knowing. The cap applies to the lowest gross rent charged in the trailing 12 months, not the current rent. So a temporary move-in discount doesn't lower the ceiling for a later increase. A landlord can raise rent at most twice in any 12-month period and cannot bank an unused increase for a bigger one later. All increases going back to March 15, 2019, when this came into effect, count toward the running 12-month total. A rule still occasionally surprises long-term tenured owners. You're also going to want to watch for local rent control ordinances, um, especially in like LA, and California's anti-price gouging law during declared states of emergency can both impose a stricter cap than the state formula, whichever produces the lower allowable rent controls. How the CPI number actually gets picked, the applicable CPI depends on which of the four listed metro areas the property sits in. So LA, Long Beach, Anaheim, Riverside, San Bernardino, Ontario, San Diego, Carlsbad, so on and so forth, using the U.S. Bureau of Labor Statistics, 12-month figure from April to April. If a metro area doesn't have an April figure published, March is used instead, which is currently the case for San Diego, Riverside, San Bernardino. Properties outside all four listed metros use the California Department of Industrial Relations statewide CPI instead. Timing matters. So an increase taking effect before August 1st of a given year uses the CPI change from 2 Aprils back to back, 2 Aprils back to 1 April back. An increase taking effect on or after August 1st, so now, uses the current pair. The final percentage is always rounded to the nearest tenth, so a 6.25 rounds up to 6.3, and a 6.24 rounds down to 6.2. Small as that sounds, it's exactly the kind of detail that turns into a dispute over a few dollars a month if it's calculated casually. Rent rollback, the provision that most agents forget when you're doing leasing. Any rent increase from March 15, 2019 onward counts towards the cap, even increases made before the law technically took effect on January 1st, 2020. A landlord who raised rent beyond the maximum during that window was required to roll the rents back as of January 1st, 2020, though any rent actually collected before the rollback didn't have to be refunded. Courts have upheld this rollback as constitutional even against an existing lease. So, but I had a signed lease isn't a defense. For legacy tenancy that's been in place since before 2020, it's worth confirming the rent history was actually corrected at the time, since a rollback that never happened is still a live compliance gap today. And yes, there are plenty of tenants that have been in the home, since 2019, 2020. So just cause. So this is something that comes up when you're doing, it could do with leasing. Mostly, I wanted to cover this part because when we are representing a client on the listing side or the selling side, this can come up because the owner is going to ask you, how can I get the tenant out? And so we have to figure out even if we can get the tenant out. So once a tenant has continuously and lawfully occupied a unit for 12 months, a landlord needs one of 15 specific reasons to end the tenancy. There's no version of the lease is up or I want a new tenant on that list. So an at fault, no relocation payment owed, so non-payment of rent, breach of a material lease term, nuisance, unlawful use of the property, criminal activity or threats, refusal to allow lawful entry, waste, unauthorized assignment of subletting, failure to renew on similar terms when demanded, and an employee's failure to vacate after termination. So those would be at fault. No fault, 1 month's rent and relocation assistance or a rent waiver is required. So owner or qualifying family move-in, withdrawal from the rental market, substantial remodel or demolition, and compliance with a government order to vacate. So those would be a no fault. Two things in 2024 tighten things up even more. Owner move-in. So this was SB 567. The owner or family member must move in within 90 days and stay at least 12 consecutive months. If they don't, the landlord must offer the unit back to the evicted tenant at the same rent and reimburse moving expenses. Substantial remodel must require the tenant to vacate for at least 30 consecutive days and be supported by an actual permit. A repaint or new flooring does not qualify, and the termination notice must include specific statutory language plus a copy of the permit. Get either of those wrong, and the termination notice is void by statute, not just voidable. Since April 2024, a landlord who recovers possession and material violation of the just cause is liable for actual damages, attorney's fees at the court's discretion, and up to triple damages for willful violations. So these are why we want to make sure we are doing these things properly and providing the correct advice. Because that could be some serious money, that the owner could be on the hook for. And when the owner gets on the hook, we tend to also get thrown into that. Yep, I'm just checking chat here super quick. We had a couple come in. If it's a 2-year lease, can we increase rent during the 10-year? Well, you just can't go past the rent cap. So the one I just said, the 5 plus the CPI. So back to this. What actual damages can really mean in practice? The law doesn't spell out exactly how actual damages get calculated. In a San Francisco case, shows how wide this range can be. The tenant's expert valued the below market tenancy itself as an asset, the gap between rent controlled and market rent over her intended years of occupancy, arriving at a lump sum figure that, once tripled under the local ordinances, damages multiplier approached $860,000. The landlord's expert argued damages should be limited to the tenant's actual out-of-pocket costs from being displaced. Sorry, my phone is ringing. So that's going to be moving costs, the rent difference at her new place, a far smaller number. The jury landed on $120,000, tripled to 360 without disclosing which theory it relied on. The lesson isn't the dollar figure, it's that a landlord attempting a no cause or improperly documented eviction is exposed to a genuinely open-ended damages calculation decided by a jury with real dissension on top of the tenant's attorney's fees, of course. So this is, if we are trying to get a tenant out on either side, um, if done improperly, could be big dollars for the homeowner, and they really need to understand that. And that's why pretty much when you come to me and you say, "Hey, we got this tenant, how do we get him out?" I immediately go to hire an attorney, an eviction attorney, or um, an eviction company, either one, because they know what they're doing. The liability gets placed on them a lot further instead of us, and we can all but be assured that it's being done properly, hopefully. So the notice periods at a glance, the termination notice itself has to match the reason. Getting one form or the timing wrong is as fatal as getting the underlying reason wrong. So non-payment of rent, you're looking at a 3-day notice, pay rent or quit, with special language required for rent owned after September 30th, 2021, referencing possible emergency rental assistance. Nuisance, unlawful use, waste, or improper assignment subletting, 3-day notice to quit, and it's non-curable. The tenant can't fix it and stay. Breach of material lease term, 3-day notice to perform or quit. If not cured, further notice can terminate tenancy. Owner family move-in, withdrawal from rental market, or substantial remodel, 60 days for a tenant who has occupied over 12 or more months. Failure to renew a similar lease on demand or a tenant's own notice to vacate not honored. No additional statutory notice period beyond what's already happened. Federally backed loans, FHA, VA. The property is secured by a federally backed mortgage. A non-payment termination may require a 3-day pay notice plus a separate 30-day notice to vacate rather than proceeding straight to unlawful detainer. So you want to confirm the loan type they have on the property. And you can start to see how this starts to really get complicated and why we hire outside counsel to handle these types of evictions. Why you can't contract around this. So both the rent cap and the just cause protections are non-waivable as a matter of public policy. That's Civil Code 1946.2. A lease clause offering a below market rent in exchange for the tenant giving up TPA rights is void. So it is a schedule of pre-agreed future rent increases built into an original lease that exceeds the cap. The law treats that the same as the same kind of waiver, just spread out over time. So if a seller or buyer proposes a clever contract workaround along these lines, the honest answer is that it won't hold up in court, and structuring a deal around it creates exposure rather than avoiding it. The exemptions and where they quietly fail. So single family homes and condos are the exemption everyone assumes applies. It only holds if two things are both true. Written notice of the exemption was given to the tenant, and since July 1st, 2020, included in the lease itself via CARS form RCJC, that's a rent cap and just clause um, addendum. And the owner is not a REIT, a corporation, or an LLC with even one corporate member. So the trap is an LLC formed purely for liability protection with no corporate member at all does not lose the exemption. But the moment a corporate entity holds any membership interest, the exemption is gone on a property that looks, in every practical sense, individually owned. So this is worth asking about directly rather than assuming. Other exemptions, new construction with a certificate of occupancy issued in the last 15 years, and owner-occupied duplex, where the owner has lived in one unit since the start of tenancy, deed restricted affordable housing, dormitories, and for just cause specifically, but not the rent cap part, an owner-occupied single-family home renting out no more than 2 bedrooms or ADUs. Section 8 tenancies are not exempt. The Attorney General has taken the position that voucher-assisted units are market rate housing, not affordable housing under the statute, and has pursued enforcement on that basis. So getting the RCJC paperwork right, so that is the rent cap and just cause document. So the RCJC is how an exempt owner actually claims the exemption, and the mechanics differ depending on the tenancy type, which is exactly where the mistakes happen. So month-to-month tenants, you're going to incorporate the RCJC either by having both parties sign it as an addendum or by delivering it as a notice of change in terms of tenancy. That is a form inside of ZIP forms. A month-to-month tenancy should be treated as renewing monthly. So if the notice route is used, it needs to have gone out before July 1st, 2020. Fixed term leases in place before July 1st, 2020. Why do they keep referencing that? That's when the date started, and there are still people in leases that we are dealing with now. So basically everything past that is applying. The RCJC should have gone out as a standalone notice before that date. You cannot unilaterally amend an existing fixed term lease during midterm. Any new or renewed lease, the RCJC must be included as part of it, full stop. And it is actually part of the lease list, the lease package. So if you see that in there, it has to be completed and signed. It is part of it. It's a very important part of that lease package, actually. Signatures and delivery. If the RCJC goes out as a change in terms notice, it must be signed by hand and cannot be delivered by email. If it's signed as a lease addendum by both parties, electronic signature is fine. So when the local law overrides the state law, and that does happen, a local just cause ordinance adopted on or before September 1st, 2019 preempts the TPA entirely for properties it covers, even if the local rule is weaker than the state law. An ordinance adopted or amended after that date only preempts the TPA if it's generally more protective, meaning it's consistent with the TPA, provides a higher relocation assistance or added protections, and the local government has made a formal finding to that effect. A property can never be subject to both at once. Practically, this means the same fact pattern, the same city, even can land differently depending on exactly when the local ordinance was adopted or last amended, which is a detail worth confirming rather than assuming based on general reputation. So again, this is why we get attorneys involved. What survives the sale? So what survives the sale of a tenant-occupied property? the lease or rental agreement on its existing terms. The tenant's just cause protections if 12 months have been in place, if they've been in that unit for 12 months or more. Security deposit credited to buyer at closing. Any side agreements, such as parking, storage, services traded for rent, etc. The 12-month rent increase look back, the lowest gross rent, any exemption already established or the lack of one. So you have a buyer buying a home that is tenant occupied. They're going to take over that home with the tenant in place. All of these things remain in effect after close of escrow. A sale is a transfer of real property, not an event that ends tenancy. Every source on this topic agrees on the same starting point. The lease rides through closing into the buyer's hands. That includes a rent history that determines future increases, the just cause clock that the tenant has already been building towards, the security deposit itself, side arrangements that were never written into the lease at all. One frequently cited example, a tenant who traded work for exclusive use of a garage. That informal deal transferred to a new owner along with the lease because it was part of what the tenant had bargained for. So we really need to be asking the right questions when we are handling these properties. And if you're on the buyer side, we want to know about these side agreements because if it's not in the lease, but there is something in place, we need to get that information for our buyer. On the other side, on the listing side, we want to ask our owner, do you have any of these things in place? Because they are going to move on through to the new buyer and they need to know about it. Otherwise, well, that's going to be a failure to disclose essentially because that's a material fact. So, selling a tenant occupied property on the listing side. So, access and showings. This is where things can get a little sticky, right? So, Civil Code 1954 requires at least 24 hours written notice before each showing. There's a more efficient option worth knowing about, and landlord can give one notice at the start of the listing period, covering entry for showings up to 120 days rather than a fresh notice every single time. If a tenant refuses entry after proper notice, you want to document the refusal and loop in counsel rather than escalating on your own. That notice is in zip forms. It's notice of sale. That's what you want to provide the tenant um, when you're getting ready to list this property. And that's basically saying, hey, we don't have to give you a notice every single time. This is your notice saying we can enter in 24 hours for a showing. Disclosure. So before the property ever hits the market, full lease terms, current rent, security deposit amount, how it's being held, and copies of every notice sent to the tenant. So these would be part of your disclosures. Any side agreements, even informal ones. If it isn't in writing, ask the seller directly whether anything was ever traded or promised. Unsolved habitability complaints or disputes. These are disclosable material facts under Civil Code 1102, the same statute behind the TDS. And skipping this one, of the more common ways these deals turn into an E&O claim. And we don't want those. Know which framework actually governs the property. So 3 layers can apply at once. A local rent or just cause ordinance, some which predate and preempt the TPA outright, the statewide TPA, and the baseline civil code rules that apply to every tenancy regardless. Pricing and marketing a listing before confirming which layer controls is pricing it on a guess about the property's most material facts. If the buyer wants the property vacant, well, that's pretty common. They don't want to deal with all this stuff. So a seller cannot manufacture a just cause reason to clear a tenant just to make the property easier to sell. Cash for keys is the common negotiated path, offering a tenant money to vacate voluntarily, but several California cities, Los Angeles being one of them, under its tenant buyout notification program, require specific written disclosures before a buyer agreement is signed, including the tenant's right to consult an attorney and after a rescission window afterward. Using a standard attorney drafted disclosure on every buyout rather than improvising language deal to deal is the practice that our E&O carrier points to directly. So this isn't really language that we should be putting into any sort of agreement because we are not attorneys and we want to stay within our scope of duty. All right, pricing and marketing the listing itself. Owner an occupied property with a demonstrably paying tenant is a different product than a vacant one, and it should be priced and marketed as such rather than treated as a vacant listing with an inconvenient occupant. A clean estoppel prepared for before the listing goes live, accurate lease terms and the listing data, and honesty about the rent relative to the market rate all shorten the buyer pool's due diligence instead of extending it into a renegotiation after inspection. Sellers occasionally push back on paying for an attorney prepared package up front. The counter is that a disputed disclosure discovered mid-escrow costs more time and often more money than getting it right before the sign goes in the yard. Buying a tenant-occupied property on the buyer side. So the estoppel certificate is the central document. And this does tend to get missed or pushed off to the end quite a bit. A tenant estoppel certificate signed by the tenant confirms the actual rent being paid, the deposit held, any side agreements, and whether the landlord has been in compliance. It's the buyer's best protection against the seller's account of the tenancy differing from the tenant's. Make getting one a condition of moving forward, not an afterthought during escrow. What the buyer is actually inheriting, the lease on his existing terms for however long it runs, plus the tenant's just cause protections if they've already crossed 12 months, the 12-month rental history. New owner does not get a fresh rent cap clock because ownership changed hands. And this is why a lot of I see this a lot, especially in like LA, where their tenants have been in the property for 10, 15, even longer years. The owner never really raised the rent that much because they were paying, they were good tenants, yada, yada. They go to sell this thing and the market rate that the rents they are collecting are far below the market rate. Well, that new buyer just can't renegotiate that lease right then and start charging a lot more. They have to follow this, and that's why these investors see those properties. They ask what the market rates are or what the rents are on it to see if they're at market rate, and a lot of them end up passing on those types of properties, or they ask for a pretty deep discount. The security deposit typically credited to the buyer through escrow rather than refunded by the seller directly. Whatever exemption status the property does or doesn't already have. If the seller never delivered the required RCJC notice, the gap doesn't heal itself at closing. If the buyer wants to move in, the buyer cannot simply terminate the tenancy at close. If the property and tenancy qualify for the owner move-in reason, the buyer or a qualifying family member still has to satisfy the same 90-day move-in and 12-month residency requirements as any other owner, and the same relocation assistance obligation applies. So you want to set this expectation before the buyer falls in love with a vacant move-in date that the law doesn't actually support. Building the timeline into the offer itself. So if a buyer plans depends on the unit eventually being vacant, that plan needs to be priced into the offer and the contingency period, not discovered after closing. Due diligence, contingency broad enough to cover reviewing the lease, the estoppel, and any side agreements before removing the contingencies gives the buyer a real exit uh, if what the tenant confirms doesn't match what the seller has represented. Waiving that review to compete on a fast close is one of the more common ways buyers end up owning a tenancy on worse terms than what they thought they were getting. Also to note, if you have, you know, especially maybe an FHA loan or an FHA buyer going for this, and you have to wait those 90 days, there is a chance that that could be a problem for that particular borrower just due to their loan type because they are required to move into that home, not rent it out for the next 90 days or even longer waiting for this tenant to get out. So, these types of properties may not be suitable for some buyers, depending on their loan type. Two things worth clearing up early. Tenant occupancy does not affect 1031 exchange eligibility. A buyer can close on an occupied property and still complete a standard exchange within the usual timelines. Many investor buyers actually prefer an occupied property with a demonstrated paying tenant over a vacant one. It's proof of cash flow, not just a complication. Frame it that way where it's genuinely true. What's actually at stake? So repercussions for owners and agents. This is what I wanted to cover because, like I said, we've had a couple flare-ups where tenants have caused some stress because they don't want to move. They want to make it as difficult as possible, and they don't care about filing a complaint with the DRE or, getting a strongly worded letter from an attorney drafted up. So let's go over this. So beyond the damages already covered, actual damages, attorney's fees, and up to treble damages for a willful just cause violation. There's a separate exposure that catches people off guard, and that is retaliation. So Civil Code 1942.5 creates a rebuttable presumption of retaliation anytime a landlord takes adverse action, including serving a termination notice. Within 180 days of a tenant engaging in a protected activity, complaining about habitability, contacting code enforcement, joining a tenant association, or using the repair and deduct remedy. Once that presumption is triggered, the burden shifts to the landlord to prove the action was for a legitimate, unrelated reason with actual evidence, not just assertion. A termination that would otherwise be completely valid can be blocked entirely as a defense in the eviction case itself, on top of separate civil penalties of $100 to $2,000 per violation. The practical implication for a sale, if a tenant raises any complaint in the months surrounding a listing, whatever happens next needs to be documented as unrelated to that complaint because the law will assume otherwise unless proven differently. So, and this is, where our complaint came from. It was essentially retaliation because this tenant did not want to move out. And so they were throwing everything they could at us and the owner, making lots of accusations that weren't true and things like that. Luckily, our agent had things documented very, very well, with all the notices, showings, camera footage, lots of different things. So we actually came out good on that one because it was just a tenant trying not to vacate. For the listing or buyer's agent, an agent doesn't have to be the one who violates just cause to end up in the middle of the fallout. If an agent advises a seller on timing an eviction, drafts or suggests notice language, or represents a buyer's occupancy plans to a tenant without confirming they're actually lawful, that agent has real exposure of their own. An E&O claim of the transaction unravels, potentially a DRE complaint if the conduct rises to a business and professions code violation, A DRE inquiry doesn't require a finding of wrongdoing to be costly. Once a complaint triggers an investigation, an agent can be asked to respond to a citation or a formal accusation, generally within 15 days, and the standard advice from real estate defense attorneys is the same as if it were for a landlord facing a lawsuit, which is get counsel involved immediately and be careful what gets said to an investigator before it happens. So just because you're doing it all right doesn't mean there's not going to be retaliation. And this again points all back to why we should advise the owners to get an eviction attorney to do this properly. That way there the tenant is dealing with the attorney a lot more than they're dealing with us. Common friction points during a sale. A handful of situations come up often enough in tenant-occupied sales that's worth recognizing them before they happen rather than reacting in the moment. None of these require bad faith on anyone's part to become a real complication. I mean, how common is this one? It's been around a little while. Entry is refused or access is limited. If the required 24-hour written notice or the 120-day blanket notice option for that notice of sale document wasn't given, the tenant is within their rights to deny a showing. Document the notice that was actually given before assuming the refusal itself is the problem. The habitability or maintenance complaint surfaces once the property is listed. This may be a genuinely new issue, or it might be a long-standing one the tenant raises for the first time now. Either way, once it's raised, the 180-day retaliation clock is running, and it needs to be addressed on the merits promptly and in writing rather than a distraction from the sale. A tenant disputes the seller's account of the tenancy, rent amount, deposit held, or the existence of a side agreement. This is exactly what an estoppel is designed to catch before it comes a post-closing dispute between the buyer and a tenant they never negotiated with directly. The tenant contacts an advocacy organization, legal aid, or a government hotline. This is a normal. I mean, this happens a lot. And there are a lot of tenant right groups out there that absolutely love to get in the middle of these kinds of things because there's money in it for them, because they all have attorneys and that's what they do. So, so this is a normal, lawful option available to any tenant who believes something is wrong, not a sign that something improper is happening on our side. It does mean any further steps in the transaction should be extra carefully documented, since a formal complaint puts a third party in a position to review the file later. So in every one of these scenarios, the actual protection isn't a clever response to the tenant. It's a clean paper trail showing the process was followed correctly from before the property was ever listed. That's true whether the tenant's underlying claim turns out to be accurate or not. Yeah, about 10 minutes left. We'll do the cash for keys. Let me check chat real quick here. On buyer side, can a buyer's agent send an addendum to a received estoppel? So basically an addendum asking a tenant about any off-lease agreements or unresolved complaints. If the buyers think the sellers may be withholding information, yeah, I mean, that's part of your due diligence, especially if you're doing it in, during your investigations period. This is all part of the investigations period, is verifying the leases and what your buyer is inheriting from this seller with regards to this tenant. I think I did that one. Okay, back to it. Cash for keys. What is it and who should run it? This is another one I stay out of. So a buyout agreement, commonly called cash for keys, is a written voluntary contract in which a tenant agrees to vacate before the tenancy would otherwise end in exchange for payment. It's formally addressed within Civil Code 1946.2 itself, the same statute behind just cause, and it comes with its own compliance requirements. A specific written disclosure delivered to the tenant before negotiations even begin. The tenant's right to counsel to counsel an attorney, a rescission window after signing, commonly 30 days and longer in some cities, and in jurisdictions like Los Angeles, filing the signed agreement with the local housing department within a set window. So if you are thinking about negotiating cash for keys, have you thought about all of this? And I'm gonna guess no, because you probably just used the form that was in zip forms or something else. So you can see there are a lot of steps to this to make this legal and binding. Why this matters more than it looks like it should. A buyout that doesn't follow the applicable disclosure and process requirements isn't just risky, it can be worse than doing nothing at all. The landlord has already paid the tenant, the agreement itself is void, and the tenant can remain in possession regardless of the payment made. That combination, real money paid out with no enforceable result, is exactly the kind of outcome an agent does not want to have a hand in. So yeah, let's say you negotiate this whole thing, you didn't follow the proper steps. Maybe that tenant's already contacted an advocacy group, or maybe they know what they're doing. They can accept the payment and say, hey, this was a void agreement, and now your owner just paid the tenant. Tenant doesn't have to move out and just continues about their business, and now you're back to square one. So this is why the standard advice and the advice worth giving every seller who raises a buyout is to have an attorney handle the negotiation and drafting directly rather than the agent. It isn't only about liability exposure, though an agent negotiating a binding waiver of legal rights is drifting into an unauthorized practice of law territory. It's that both sides are better served by independent counsel on a transaction that is, by design, a negotiated release of statutory rights. The tenant can get advice on whether the number is fair and the process is being followed, and the owner gets an agreement that will actually hold up if it's ever challenged. It's an agent's role to flag when a buyout is on the table and recommend counsel promptly, not to be the one at the table negotiating it. The broader enforcement landscape. A tenant doesn't need to hire a private attorney to create a real problem for a non-compliant transaction. California's enforcement landscape for the TPA has gotten meaningful wider in the past 2 years. The Attorney General's Housing Strike Force, established within the California DOJ, it runs a tip line, holds tenant roundtables around the state, and has pursued real enforcement, including a $3.5 million judgment against a large investor for unlawfully evicting tenants out of foreclosure sale properties, and a settlement with with at least one owner specifically over TPA violations. City attorneys and county council statewide, so SB 567, which was effective on April of 24, gave every city attorney and county council in California, not just the attorney general, express authority to enforce the TPA directly. Enforcement is no longer something that only happens at a state level or in the largest cities. Legal aid and tenant advocacy organizations. These groups operate tenant hotlines, provide free or low-cost representation, and are a regular source of the tips and the roundtable input that inform where the strike force and local prosecutors focus attention. Contacting one is a normal available option for any tenant, not an escalation that itself signals wrongdoing on either side. But they're out there and they're looking to violate owners and agents and anybody else involved when, a tenant makes a claim that their rights have been infringed. The practical read for a listing built around a tenant-occupied property, assume that any misstep has more than one path to become a real problem: a private lawsuit, a DRE complaint, or a referral into a much wider enforcement net that existed even 2 years ago. The response to that reality is the same one that runs through the entire uh, presentation: correct paperwork, timely disclosure, and documentation that would hold up regardless of who ends up reviewing it, because you always have to assume that it could be reviewed, that all of your communications could be turned over. That's all part of the file. That's all part of what can be, um, summoned from the investigator. Um, so a worked example, start to finish: single family home has been rented to the same tenant for 3 years. The owner holds title through an LLC set up years ago with a business partner who later incorporated their share of the partnership. The owner now wants to sell. Listing side step one: confirm the exemption status before pricing the listing. Because one new member of the LLC is a corporation, the single family exemption doesn't apply here. Whatever the owner assumed, this property is fully subject to TPA. Step two on the listing side: check whether RCJC notice was ever sent. If it wasn't, and it wouldn't have mattered anyway, given the corporate member issue, that confirms this tenancy has been on the standard TPA track the whole time. Rent cap and just cause both in effect here. Listing side step three: assemble the disclosure package before marketing. That's going to be your lease, current rent, deposit amount, every notice sent to the tenant, and a request for an estoppel to have ready when an offer comes in. On the buyer side, step one: make the estoppel a contingency, not a courtesy. If the tenant's confirmed rent or move-in date differs from what the seller represented, that's information the buyer needs before removing contingencies, not after. Buyer side step two: the buyer wants to occupy the home themselves. Walk them through the actual owner move-in timelines. 90 days to move in, if 12 months of residency, relocation assistance paid, before they write an offer, assuming a quick vacant possession. Buyer side step three: if the buyer is another investor, instead, the tenancy is an asset, not an obstacle. Confirm the rent is at or near what the cap would currently allow, since a tenant paying well under market with 3 years of tenure represents a bigger gap between the current and allowable rent than a newer tenancy would. Nothing about this scenario is exotic. I mean, this is pretty cookie cutter, actually. We see this a lot. In its ordinary case, a small owner who didn't realize their entity structure mattered, a rent-controlled tenancy nobody had recently looked at closely, and two agents who have a specific checkable job to do before their client signs anything. So, yeah, I mean, we have like a little bit left. I can do the price gouging overlay real quick. Separate from the TPA, California's anti-price gouging law can cap rent increases at 10% the moment a state of emergency is declared for the county where the property sits, whether declared by the governor, a local agency, or the president. This has been live in various California counties continuously in recent years, covering everything from wildfire to the pandemic, and it applies on top of whatever the TPA already allows. So if a declared emergency has been continuously in effect in a given county for years, a landlord there can be limited to a single 10% increase for the entire multi-year period, well below what the TPA formula alone would allow. Before advising a seller or investor buyer on a projected rent growth for a specific property, check the county's current emergency declaration status on the Governor's Office of Emergency Services site, rather than assuming the standard TPA math is the only limit to pay. And then there's a copy of this. That question comes up every week, but yes, re-record every one of these. They are all in the back office under the training and motivation tab. And we do include this presentation as well. So we have the recorded video and the presentation material if you just kind of want to skim through. We do have a disclosure package if you want in here, a checklist before you list, and some comment pushback and how to respond. Um, that's probably a fun one, but it's already 10 o'clock and I want to be mindful of your time. So that's about it for today. What do you think California's rental landscape will look like in 10 to 15 years? Well, there's a lot of landlords cashing out. So 10 to 15 years, I mean, I think the whole world's going to be different in 10 to 15 years, but I think in just a couple years, the rental landscape, it's only going to be more restrictive. You know, that's the direction it's going. There's constantly bills being proposed that seem to restrict homeowner rights when renting property. So, yeah, it's definitely tightening for landlords out there as far as their protections. It is definitely swinging hard towards the tenant. So if you have investors looking, you know, maybe they're newer investors and they want to get into, you know, buying and holding properties for rent, you know, they should really take a look at how their local ordinances are and, you know, track records of the house and make the decision there if that is the right move that they want to make. Um, all right, so that's what we have for today. Hopefully that was informative. Uh, did I mean to scare you? Yes, maybe a little bit because again, these are common transactions, having a tenant in place, and we really need to make sure that we are advising our clients on either side properly and looking at the correct documentation that's been in place. And you know, I am always going to advise to seek an eviction attorney if you need to get a tenant out or an eviction company who specializes in that kind of thing. I do not like messing with it myself. Um, as you can see, there is a lot of laws and regulations that go around doing this properly, and one misstep can throw the whole deal off. It can get you in a complaint with the DRE from the tenant or worse. So, you know, don't try and take on everything just because, you know, that owner wants you to do it for them because they think you're going to do it at no cost, essentially, or, you know, part of your fee that you're charging. It's really not worth it. The advice should be we need to get a professional on this. This is outside my scope of duty, essentially. Because again, we are not a property management firm. We don't specialize in evictions. All we do is leasing. So when you're doing the leasing, just make sure you're paying attention to the rent caps for the local area. And the formula is in here if you want to check it out for review later on. But other than that, I hope you have a great week and hopefully that was informative. And thanks for attending. And if you have any questions, always give me a call. We'll talk to you later.